everybody, welcome to my channel, Life, Law, Bin. Now, it's interesting because everyone knows that you're a criminal practitioner. So when did you actually know along your journey that you wanted to specialize in crime?
Well, at the beginning, I did everything. So when I went to the bar, having left the Crown Prosecution Service, I did family, chancery, civil, criminal, anything and everything that came into chambers that a junior member of chambers does. And then after a while, I did a lot of family work and a lot of criminal work. And there came a point where it was said to be appropriate to specialise, that we all had to choose a field. And I knew I wanted to do criminal law at that stage because of the advocacy, because I am most excited about being an advocate, pitting my wits each and every day in a courtroom, trying where I can to be a voice for someone who doesn't really have one, helping very vulnerable people to trust me, to understand that I'm there for them, looking after them, that I'm not just part of a system that is going to reject them, and then being a voice for the person that I'm speaking for, hopefully with a conclusion that means the best conclusion for them. Now, you don't always win. You absolutely do not always win in this job. And success is a very interesting word. Chambers everywhere will put out such and such a person successfully did this, that, or the other. Whereas in fact, you may do your best work and fail, because you can only work with the case that you have. But what I do know, why I can sleep well at night, is that I know that I give everyone I represent the absolute best service that I can. And just being able to explore evidence, expose inconsistencies, try and help a jury to determine where the truth lies, for me, that's the best job in the world.
Good, good. Now, the thing about criminal, it definitely attracts those of us who are very, very big on oral advocacy because
Yeah.
we know that you can practice your skills or hone your skills from the inception of a case right to the
Mm.
conclusion. But many students who are interested, as you know, in becoming criminal practitioners are concerned about the impact of legal aid cuts on the criminal bar. So how has this affected your career so far, and what advice would you give to aspiring barristers who are keen on practicing this area of law but are worried about being paid less than minimum wage?
Well, I think the first thing is to just look slightly behind the headlines. I've been doing criminal law for 30 years, and I'm not living in poverty. And I'm not living, and I wasn't living as a junior in poverty. The cuts to legal aid are well known, and they are something that can easily be looked up. Whether you earn a good living is all relative. So what might be a good living for someone of privilege is not necessarily the same as what is a good living for someone else. So for me, I have always made a good living from criminal law. I own my own home. I have good holidays. I have a car. I've been able to bring my children up. I'm not living in destitution or poverty. And the position in relation to criminal law is this: you get a paid pupillage. So you will earn at the very worst the minimum wage that is provided by the Bar Council for pupillage, and you will obtain your expenses as well. Most criminal practitioners, within 5 years, most should be earning £50,000 or more. Senior juniors can earn anything between £50,000 and £80,000 a year. Really senior juniors can earn anything from £80,000 to £150,000. Now, to me, that's good money, because if you compare it, for example, with being a teacher, joining the civil service fast track system, even being a junior doctor, you will see fairly quickly that the figures are, well, you could compare them, and you can make a choice about whether that's enough for you to earn. If your main focus in becoming a barrister is earning a lot of money, of course you can earn more money in other fields. So family law pays more than criminal law, and civil and commercial law probably pay more than family law. But it's a balance between what you love and what you want to earn. So for me, I want to live a long and happy life, and money is not my first priority. It is obviously important, because I don't have any form of private income or anything of that nature, but it's not everything to me. So my choice was to do the area of law which I find the most exciting, which I enjoy getting up for work for, and I knew I'd enjoy getting up for work for until I stopped getting up for work. Other people do other work. So I would say just be realistic. Don't live, for example, miles and miles and miles away from your chambers, and then work out that you've got huge traveling expenses. Think about living close to where you work. Understand what you're likely to earn and work out whether that's enough for you, and then make a choice. But again, people will say, oh, there's no money in criminal law, but no money is a relative thing, because for many people, the sorts of money that criminal practitioners on is a lot of money.
True, true. Now we do know that you within criminal there are quite a few practice areas, and for those viewers that are watching, I always like to kind of unpack what a practitioner can practice. So the subsets within criminal law. So we do know that you do a bit of practice in terrorism, homicide, rape and serious sexual offenses, financial crime and fraud, regulatory and large scale conspiracies to import drugs. Now, could you tell us a bit about your practice, and how you would have went into to choosing those kind of niche areas or pocket of areas within crime?
I think to a large extent, Nia, they choose you. So you start out doing everything, and you will find your particular skill set. So I think if I were to look across my practice areas, the common theme would be, for the most part, that I am chosen to represent vulnerable people. And so whether it's someone who is charged with being the leader of an organized crime group, or with being someone who's caused the death of one or more individuals, generally the people I'm asked to represent are those who've grown up in the looked after care system, who have mental health difficulties such as autism, ADHD, who have learning disabilities, who have physical disabilities or emotional difficulties, which mean that they struggle to cope with the court processes, or those who have been subjected to significant and substantial physical, emotional, or sexual abuse. So those clients stretch across all of those areas of law. And I think there is more in common between different aspects of criminal law than there is that is different, because all that is really required is the ability to read the law in the various fields and then to fit that law to the facts of the case that you find yourself in. I'm a little bit wary of categories of criminal law because it can become clubs, and it can become clubs to a certain extent for the privileged. So if you are an aspiring criminal practitioner and you want to get into terrorism, for example, very difficult if no one else in your set does it. And so a solicitor will choose someone with experience in that field, and therefore you never get experience in that field. And so it can become a smaller and smaller club. And there may be a tendency for people in those clubs to hold on to that type of work. But actually, almost all criminal law is accessible to every criminal practitioner. And the skills that you have are the same skills that you need for other work. I suppose the one different area would be rape and serious sexual offences, which does require quite specific training, particularly in the questioning of vulnerable witnesses, because often in those cases you have children who are the main complainant, the main person who is suffering some form of abuse. And sometimes you have children being accused of abusing children. So there are all manner of difficulties in cases like that. But all of my work really tends to have one theme.
You know, it's interesting that you said it can go into, well, be divided into clubs. What advice would you give to a young practitioner who wants to get into a particular set or a particular area in their practice, but no one else within Chambers does it? How do you think they can develop a practice in that area?
I think you have to think outside the box a little bit. So the first thing to do is to go to a variety of talks. And these are mostly virtual now, so that's quite easy. So go to a variety of talks on that topic. If there's an association for lawyers who deal with that work, do that. And get in touch through your clerks with the solicitors who do that type of work. Indicate that you are interested in it. And you can, if you want to, through your in, get a mentor who works in that field. And they will take you to a case and you can observe that case and observe what goes on. And then you are in a better position to try and get that type of work. But I think also, if you develop relationships with solicitors who instruct you, and you do a good professional job for them, they will be willing to give you a try in an area that may be outside of your expertise because they know that you do a good job. And so when I started off, as you'll remember, I said to you I was in a very small set that didn't really get a lot of Crown Court work at all. But the solicitors who I was working for in the Magistrates Court did give me work in the Crown Court, and they did take a chance on giving me that type of work. And obviously, I reflected that by working extremely hard on it. So there's always a way around these difficulties. You just, when you've had to work hard to get where you are, you have learned such valuable skills, and you just need to feel confident that you have them and work with those skills to find an opportunity.
Yeah, I think it's always opportunity meets preparation. So it's about, as you said, attending these different talks, making links with a mentor, and then pursuing it. Now, there is when we pursue during the bar course, sorry, we learned that from day one of practice, we're supposed to be providing a competence service, competent standard of service. And that has to do with being able to deal with clients of all kind. So what advice, because we know that your work makes you an expert dealing with vulnerable witnesses or vulnerable victims. So what advice would you give regarding how to provide a competent standard of service to vulnerable clients?
I think the first thing to understand is most vulnerable clients don't know they're vulnerable clients. Many people who come into the criminal justice system have never, in fact, been diagnosed with anything before they are alleged to have committed a crime. And frightened people are often angry people. So when you are first starting out, you may go down to the cells, for example, or you may go to court and meet a very angry person. And that person may be shouting and telling you that they're going to sack you because you're a woman, or because you're a particular type of woman, or because you're young, or whatever. And that is almost always fear. But people who are frightened like that, particularly those who've grown up in the looked after system, have no way of knowing how to express fear like that. And so they just express it with anger. And I always think that the best thing that you can do is to understand how you would feel if you were in that position and you were meeting a complete stranger. And the real key is listening. Try, if you can, to say very little and just listen to that person and hear what it is underneath all the rant and chat and all. What is it underneath all of that is the major problem? And then talk to that person as if they are a human being with compassion, and then play back. So make sure they understand what you've told them. So, right, I've been speaking for a minute or two now. Can you just tell me what it is I said to you about this? And then if they tell you and they understand, you know that you've got an understanding. If they tell you and they don't understand, you know that you've got a problem, because you're going to have to adapt your questioning style to develop that skill. And be very wary of people saying yes to you, because those with learning disability will often say yes because they've learned it's easier, and because they're embarrassed, perhaps unnecessarily embarrassed about their limitations. So the key is to listen, look for understanding, and make sure you never forget that you're not important. You are not important in this job. You are there to be the voice of someone who's important. And the person who's important could be any member of society who is either accused of a crime or a victim of a crime. Both of those people, they have a right to be heard. And your role is to ensure that they can be heard. You're not anything special because you're a barrister. That's the job you're doing. And so don't talk over people. Don't think you're better than anybody. And don't use words that ordinary people don't understand. And the real lack of skill amongst junior barristers nowadays is being able to talk to strangers, because people don't meet anyone outside of their bubble, the bubble being sixth form, trips away organised by school, holidays organised by parents, going to university and then mixing with the people in university, and never really going anywhere by themselves, doing anything by themselves. The biggest skill to learn to be a good barrister is being able to talk to anybody. And if you can do that, you're almost halfway there.
Brilliant advice. And for those people listening keenly, I think that that definitely is the reason why most chambers ask you to demonstrate that you can talk to all members of society, to list some kind of experience where you've been working with the public. Because I feel like the hardest thing to do is to try to assist or advise someone and you can't even relate to them, you can't talk to them. That's going to be a difficult task, especially if they think that you are being condescending or looking down on them. That's going to be difficult. I wouldn't want you to represent me personally if I feel as though the person that's in charge of representing my interests is being condescending towards me. I wouldn't want that. So
No.
yeah, I think sometimes we have to put the application questions into context. Maybe ask why are they asking me this, as opposed to seeing it as, oh gosh, another question that I have to write about.
One
Yeah.
of the hardest questions people find to answer is, give me an example of a time you've spoken up for someone in a circumstance where they weren't able to speak up for themselves. And you see brilliant academic candidates just sitting there going, yeah. And the other one is, can you give me an example of a time that you failed at something in life? And you can see people going, I don't think I failed at anything.
I'm just brilliant.
I'm just absolutely stunningly brilliant. What could I possibly have failed at? And here's the major problem. Failure is a real part of progress in this job and in life. So if you're not failing at anything, you're not going outside your comfort zone. You're not doing things that you're not used to doing. And it's great to fail because firstly, it makes a different part of your brain work. And if you try and do something new that you've never done before, that's great brain exercise. But also, it's human to fail. And you need to be human and you need to understand human emotions to explain them to a jury, which is made up of 12 human beings.
Indeed. Mary, you're on a roll here with the advice, and yeah, with the inspirational, encouraging advice. And most of all, it's frank, it's candid. So that's what we need. So I'm going to continue and ask you another question. What advice would you give to those who wish to pursue a career at the criminal bar? Now, we've gotten quite a bit from you, but what two things do you think are very important takeaways?
Ooh, that's a great question, Leah. Um, if you want to pursue a career at the criminal bar, do it. Do it. That's what I would say to you. And how do you do it? Well, firstly, while you're doing your degree or while you're studying for your bar course, instead of flicking through social media when you have a break or whatever else you might do, go to court. Go to court. Go and sit in your local magistrates or Crown Court and watch. Go as often as you can, even if it's just for an hour, and watch, because you will learn so much by watching what people do, particularly watching what they shouldn't do. Seeing it done badly is worth far more than seeing it done well. Learn how the court works, how the staff are treated. Learn just what everybody does, the procedure and so on, because it will save you so much time once you start practicing. And secondly, while you're there, just watch the social interactions between people. See what works and what doesn't work. Remember that the very best of us will know the names of the security staff, will know the names of the cleaning lady or gentleman, will know the court clerk's name and how they get on in their families and what they've been up to. Because kindness, humility, and decency gets you a very long way in this job. And I can tell you that if you go and sit in court regularly and watch, the judge will notice you and may well have a chat with you at some stage. The advocates will come and chat with you once they know that you're a law student. And you may find experiences open up to you that you would not otherwise have got. But if you don't go to court while you're doing this, what you're doing really is that you're learning academically how to drive a car without ever having been in one. And that makes it a lot harder for you. So just go and watch.
Yeah, but that's outstanding advice, because I think most of us just sit and probably wait for the more traditional avenues of work experience. So we may be waiting for the mini pupillage in order to go to shadow a barrister, when really and truly we can just get up and go and sit in the public gallery and watch the day's proceedings. So I definitely think that's something that we should bear in mind, because most of the time we complain, some of us complain and say, well, there are no opportunities. There are no opportunities to get any experience on my CV. And I think we see that as maybe trivial, as a what am I going to learn? How am I going to write that on my CV when I go and I sit there? How does that really set me apart? I've got to do everything else except that. So I feel as though we sometimes disregard the easier, in quotation marks, option of just going and attending and viewing, observing.
Well, it would demonstrate very clearly your interest in being a barrister. And mini pupillages don't always. People amass them like blue Peter badges. You know, I've done 6 mini pupillages. I don't care. I don't care how many mini pupillages you've done, because all you've put on your CV is that you've done them. Now, you may have got those because you've had privilege in your life. You may have got those because you know people who can give you openings into mini pupillages. Tell me what you learned there. Tell me what you observed and what you learned from it. But if you can't get any, then just show me that you're interested in being a barrister by saying, I applied for 20 mini pupillages. I didn't get any. So every Tuesday and Thursday afternoon, I went to my local Crown Court and I watched proceedings. And these are the things I watched. And I got to talk to the following. What's not to love? You've shown initiative, you've shown persistence, you've shown resilience. That's a tick.
It's a giant tick, isn't it?
It's a giant tick.
It's a giant tick. Now, Mary, we've spoken about your experiences as a barrister, and I want to kind of flip the script a bit and speak about your experience being a recorder of the Crown Court. And let's kind of demystify the jargon here. So let's start very simply. What is a recorder?
A recorder is a part-time judge. So we sit in my case, I sit in the Crown Court and I sit in the Family Court, and we do all the things that judges do, full-time judges do, but we sit part-time. So we still do our day job on
And
different days, obviously.
and what are your roles and duties as a recorder?
The same as a Crown Court judge. So I sit on the Northern Circuit. So that's effectively Manchester, Liverpool, Preston, Carlisle, and Chester. And I am the judge in cases where there are trials. I deal with the administrative matters in the early stages of cases. I deal with sentencing. I deal with Newton hearings where I have to decide what the facts are after someone's pleaded guilty. And I deal with ancillary matters like proceeds of crime applications, sexual harm prevention order applications, and things like that.
Did your perspectives on practicing at the criminal bar alter when you were in the viewpoint of a recorder?
It's very different sitting looking into the courtroom than it is sitting with your back to the accused and just having the judge in your focus. So when you're sitting in a Crown Court trial as an advocate, the only person between you and the judge is the court clerk, and the defendant is behind you and the jury are to the side. And generally we don't tend to stare at the jury. That's very much frowned upon as advocates. As a judge, your view is obviously you see the advocates, then the accused, then the public gallery, and all of the jury. So your perspective is very different. You get to see a lot more of how people are behaving and what people are doing. So you will notice, for example, if a defendant is not paying attention or becoming agitated or becoming distressed in a way that their advocate can't, because their advocate has their back to the person. You also understand, because advocates are speaking to you, why it is sometimes that you can frustrate a judge when you're an advocate yourself, because of course I now realize the order that a judge would prefer to have information in. And I now also realize how frustrating it can be sometimes when you ask a question and the advocate simply doesn't answer it. And I now see that from a very different perspective, but it is a very, very different role, because as a judge, my obligation is to uphold the law and to ensure that I make sure that there is a fair trial for anyone who is accused, and also that everything I do is simple and clear so that everyone within the courtroom understands it. I'm not there for any side, which is a very new role for me. I'm there to be a minister of law and justice if we reach the stage where I'm having to administer.
Now, given that it was completely different, you're in a different perspective. Describe any adjustments that you had to make, or any differences that you observed between sitting as a recorder and being a barrister.
Well, the first thing I had to do was to shut up, because as a judge, my role is to listen and not interrupt. Whereas an advocate, if I'm listening as an advocate to something that the other advocate is saying that I might disagree with or think he's got wrong, then I would be interrupting. So you have to learn to listen and shut up. That's the major change, I think. But also, you must learn very much to remove emotion from you as a judge. You are there to hear the evidence and to determine sentences, and none of that is assisted in any way by allowing your emotions to come into play one way or another. And you must learn patience, and you must also learn to just allow advocates to do the job that they're doing and ask questions at the very end. So just learning that different role takes a little bit of getting used to.
Now, I noticed before you mentioned that there's a particular order in which judges may want to hear the information. So, for junior practitioners, what advice would you give, to those of us who are maybe presenting a submission to the judge? What do you think we can do to make that submission more effective and to fit that particular order?
I think the first thing to do is to tell the judge what it is you're going to be saying, and then tell him the that you have 3 or 4 key points and that you're going to go through those points with him or her. So in other words, my application is this. So this is the application I'm going to be making to you. And I'm making it for 4 reasons. 1, 2, 3, 4. May I take those? May I take you through those in turn? Because often what advocates do is they don't tell you what they're asking you for. They just talk. And then sort of 5 minutes in, you've still got no idea what it is they're actually asking you to do. And you will say, can you just tell me what it is you're asking me to do? And then you get this face, which goes like this. And then they carry on with the script sometimes that they've written. So I think what you need to do is always be clear and concise. The shorter you can make submissions, the better. Just tell a judge what your application is and why. You might find if you do, they say, well, I agree with that. You can save yourself a lot of hard work and heartache. And also, if you prepare to talk in that manner, this is what I want and this is why I want it, it makes your submissions very clear in your own mind. And you must always, if you can, keep things in simple terms, because your audience is not always someone who is an academic or someone with a degree. And so it's important that the person you're making the application on behalf of also understands it. And we all get caught up in legalese and verbal words and saying things because we've learned these phrases. I can't gainsay it is one. No one speaks like that. Or just long phrases that don't actually really help the conversation that you're having. So just make your submissions short, simple, and clear, and judges will very much appreciate it.
I think that that seems to be a key takeaway. Even when we do mooting, that seems to be the key takeaway.